Okay, this is a meeting of the directors of the Brooklyn Arena Local Development Corporation. I'm Bob Megna. Good morning. I now call to order the meeting of the directors of the Brooklyn Arena Local Development Corporation for Monday, August 8th, 2016. I'd like to note for the record that I will be the acting chair for today's meeting and that this meeting is being webcast. The directors have received written materials in advance of today's meeting, and they are free to ask questions at any time. Please note that we welcome public comment on the items on the following agenda to ensure maximum opportunity for participation. Excuse me for a second. I don't know why that's happening, but you can still see me and hear me, right?
Yes.
Clearly, yes.
All right, I'm going to continue then. To ensure maximum opportunity for participation, speakers representing themselves may speak for up to 2 minutes each, and those representing groups may speak for up to 4 minutes with one speaker per group. Speakers' comments may address only items considered at today's meeting. Before we begin with the substantive portion of the meeting, I would like to ask the directors whether anyone has any potential conflict of interest with respect to any of the items on the agenda. If so, I would ask you to please make an appropriate disclosure on the record at this time. We will then be sure that you may recuse yourself from any discussion or vote with regard to such item or items. If not, I'll continue. The foregoing have been noted for the record. I would now like to request Jonathan Byer to present the items on today's agenda. The first item is for authorization to appoint corporate officers, elect the chairperson, adopt revised guidelines for the use, awarding, monitoring, and reporting of procurement contracts, adopt the whistleblower policy, adopt investment guidelines, adopt the annual report, and transact other necessary corporate business of the corporation. Jonathan, I hope you're ready for all that.
I hope so as well. I didn't bring a glass of water, but I'm going to carry on. Thank you. Good morning to everyone. The Brooklyn Arena Local Development Corporation, the corporation, or as we refer to, BALDAC, is a charitable, not-for-profit corporation. The corporation was formed to finance certain components of a redevelopment project in the Atlantic Yards area of Brooklyn, New York, including the design, development, construction, and operation of an arena for use by a professional basketball team and for other sports and arena events. The corporation undertakes its public purpose by issuing federally tax-exempt and/or taxable bonds. In 2009, the corporation as issuer issued approximately $511 million of its pilot revenue bonds, Series 2009 Barclays Center Project, to be referred to as the Series 2009 pilot bonds. The Series 2009 pilot bonds were issued primarily for the purpose of providing a portion of the cost of acquisition, design, development, and construction of an arena, now known as Barclays Center or the Arena, and certain other improvements related to the arena. Construction of the arena was completed in 2012, and the arena is currently being used as the home venue of the Brooklyn Nets and New York Islanders and as a venue for other entertainment, cultural, sporting, and civic events. The Series 2009 pilot bonds are special limited obligations of the issuer, payable primarily out of revenues of the issuer derived from certain payments in lieu of real property taxes, or pilots, made under a payment in lieu of tax agreement dated May 12, 2010. Arena Co., or Brooklyn Event Center, LLC, is a wholly owned subsidiary of Brooklyn Arena Holding Company, LLC, a Delaware limited liability company, which in turn is a wholly owned subsidiary of Brooklyn Arena LLC, also a Delaware limited liability company, the arena developer. Arena Co. is the tenant of the arena project and has made and will continue to make pilot payments to the New York State Urban Development Corporation doing business as Empire State Development, known as ESD, under the pilot agreement. ESD owns both the ground and arena, which imparts the tax exemption for the pilot. Corporate officers. Due to resignations, the corporation has several officer vacancies. Staff recommends that all such positions be filled by the individuals noted in the attached resolution. All the proposed officers have served or are serving in similar capacities in other state entities. Robert M. Godley, appointed as treasurer in September 2009, continues to hold his office. Adoption of revised ESD guidelines for the use, awarding, monitoring, and reporting of procurement contracts. These are known as the 2016 guidelines. The 2016 guidelines attached to your materials set forth the policies and procedures to be followed by the corporation when seeking to contract for goods or services. It should be noted that these guidelines do not have the force of law, are required only of public authorities and public benefit corporations, not local development corporations such as Baldac, and are proposed as a statement of best practices and procedures. No contract is invalid merely because the 2016 guidelines have not been followed. The guidelines define the universe of procurement transactions which are subject to the policies and procedures. Generally, all procurements by the corporation must be competitive, except where state law provides for non-competitive sourcing. Adoption of ESD whistleblower policy and ESD investment guidelines. The Nonprofit Revitalization Act of 2013 requires not-for-profit corporations with 20 or more employees and annual revenues exceeding $1 million to adopt whistleblower policies. These policies are meant to protect directors, officers, employees, and volunteers who make good faith reports of actions or suspected actions taken by or within the corporation that are illegal, fraudulent, or in violation of any adopted policy of the corporation. Staff recommends that the corporation adopt the ESD whistleblower policy. The New York Prudent Management of Institutional Funds Act requires the adoption of an investment policy by all corporations subject to its provisions to ensure that the investments of the corporation are prudently managed. This statute applies to all corporations incorporated under the not-for-profit corporation law, including the corporation. Staff recommends that the corporation adopt the ESD investment guidelines. Adoption of an annual report. The not-for-profit corporation law also requires that the board of a not-for-profit corporation present annually a report to members showing certain financial information and ratify the adoption and presentation of the annual report to the members. Staff recommends that the board adopts Note 3C of the audited combined financial statements of the New York Job Development Authority as of March 31, 2015 and 2014 as the annual report of the corporation and ratify all such prior reports. Finally, the chairperson. I apologize that there's a typo in the materials, but the intended appointed or chairman is not going to be Howard Zemsky, who is not a director. He's a director on almost all our other corporations, which is how this escaped notice. But if the board is fine with the substitution of Robert Megna, who's acting as acting chairman today, the approval today will signify election of Robert Megna as the chairperson of the corporation. Accordingly, the board of directors of the corporation are being requested to appoint corporate officers, elect the chairperson, adopt the annual report, adopt the 2016 guidelines, adopt the whistleblower policy, adopt the investment guidelines, and take related actions.
I'm going to recuse. Should I recuse myself from voting for myself? Are there any questions or comments from the directors on this item?
No questions.
Are there any comments? Are there any comments from the public? If not, I'll entertain a motion for approval.
So moved.
Second?
Second.
All in favor?
Aye.
Aye.
Yes, aye. I guess that passes. Thank you. Jonathan will now present the next voting item, which is for the adoption of a corporation conflict of interest and related party transaction policy. Jonathan?
Thank you. The statutory section of the Not-for-Profit Corporation Law, the statute, requiring the adoption of the conflict policy was signed into law in 2013. The statute works in coordination with multiple other provisions of the Not-for-Profit Corporation Law, including definitions of related policy transactions, relatives, affiliates, and key employees. The conflict policy, along with the required questionnaire for directors and examples of conduct and activities that could be deemed conflicts, is based on these statutory requirements, as well as policy models adopted by other not-for-profits, all with the intent of protecting the corporation from transactions that might create a conflict. The Board of Directors is now being asked to approve the conflict of interest and related party transaction policy attached. For informational purposes, the Corporate Secretary will be providing copies of the policy and the applicable questionnaires to the appropriate officers and directors. And I just want to point out that we purposely made this a separate item for the board to approve because conflicts of interest are of extreme importance to the state, to all of us who work here, and to the public. And so because these policies have received heightened scrutiny and people's service for the state has also received that kind of scrutiny, we decided to make this a separate item so the board would really focus on the importance of this conflict of interest policy.
With
that,
ready,
I would request, yes, we're ready.
Are there any questions or comments from the directors?
Yes, this is Peter Kiernan. I just want to point out that the conflict of interest provisions, the key employee provisions, and I think related party transactions were the subject of heavy negotiation and legislative negotiations. And many amendments to those provisions were passed by the legislature in June. I don't know yet if the governor has signed them into law, but since the corporation is adopting this policy and calling emphasis to it, I think someone should be directed to review the new statute if it's passed and revise the policy as necessary.
So noted, and I will make a note to do that myself.
Thank you, Peter. Are there any comments from the public on this item? If not, I will entertain a motion for approval.
So moved.
Second.
Is there a second?
Yes.
In that case, all in favor? Aye.
Aye.
Any opposed? Okay, next item. Jonathan will now present the third item on the agenda, which is for the establishment of a pre-qualified list of legal counsel. And again, Jonathan.
Thank you. In April 2012, staff of ESD advertised and solicited responses to select a team of legal counsel in 9 different practice areas for ESD's legal matters, including those carried out by ESD's subsidiaries. Based upon review of all relevant criteria, ESD selected a list of counsel in 9 practice areas, including legal counsel to assist in the sale of the bonds, to remain in effect for 3 years with an option for the ESD General Counsel to extend that term, and that option was exercised. I would note that ESD is now in the process of conducting a new RFP process, and the ESD board is expected to approve that list in the near future. However, the action today seeks the corporation's adoption of the current ESD pre-qualified list of counsel, which would then make these firms available for future recommendation to the corporation directors for retention as the need may arise without the need to conduct a further solicitation. And that future is coming very shortly. At this time, the directors are requested to approve the ESD slate of legal counsel as set forth in the materials.
Any questions or comments from the directors?
No.
Any comments from the public on this item? If not, I will entertain a motion for approval.
So moved.
Second.
Thank you. All in favor? Aye.
Aye.
Any opposed? Okay, thanks. Jonathan will now present the next three items, which are for the procurement of legal services. When you're ready.
Thank you again. This is a request to appoint Mintz, Levin, Cohen, Ferris, Glovsky, and Papio, PC, counsel or Mintz, from the pre-qualified list of counsel to serve as co-bond counsel to provide legal services to the Brooklyn Arena Local Development Corporation in connection with the issuance of bonds to refund bonds issued to fund the construction of the arena at Barclays Center. A request for approval of those bonds will also be presented to the board later this morning. All counsel fees for the bonds, including counsel fees at discounted rates, and all affiliated eligible costs of the bond transaction shall be payable only up to an aggregate amount equal to 2% of the proceeds of the bonds. This counsel will also be required to use good faith efforts to achieve an allocation of 30% of total billings on this matter to co-bond MWBE counsel, the Hardwick Law Firm, LLC, to be retained under a separate retainer. The contract with the firm is expected to be funded in its entirety by bond proceeds on or about the closing of the bonds, which are repaid by pilot payments from Brooklyn Events Center, LLC, or Arena Co. Pursuant to a Notice to Proceed, or NTP, issued by the New York Transportation Development Corporation, which is another local development corporation with similar powers to Baldac, Counsel has already commenced providing legal services to issue the bonds. Counsel has agreed that any contract for services, such as the NTP, would be deemed assigned to Baldac, and Mintz also agreed to then enter into a retainer with the corporation for all services and obligations described herein. These terms, which I just discussed regarding the 2% cap, the discounted rates, funding from bond proceeds, the notice to proceed and its assignment, and selection from the pre-qualified list, will also apply to the two counsel that will be requested to appoint following this item. With respect to Mintz and this transaction, the selection was based on solicitation of 3 firms from the slate of pre-qualified counsel. Respondents were requested to describe their experience with arena financing, pilot bonds, local development corporations, and willingness to partner with MWBE firms. Mintz provided the most persuasive combination of experience and expertise. Mintz was also the same firm that represented the corporation's bond counsel on the initial bonds for the arena. Mintz also served as bond counsel on the recent issuance of Liberty bonds to finance the Goldman Sachs global headquarters in Lower Manhattan. Accordingly, staff recommends the retention of counsel for the bonds based on counsel's specific and necessary expertise as bond counsel, counsel's performance with distinction on the initial bonds, counsel's rate proposal, and the ESD pre-qualification process. The directors are now asked, well, I'm going to actually wait for request for authorization until we do all 3. If that's okay with the directors?
Yes?
Okay. The next item is a request to appoint the Hardwick Firm, LLC, counsel or Hardwick, an MWBE firm, as bond counsel to provide legal services in connection with the issuance of the refunding bonds. As just noted, all the terms regarding the cap, discounted rates, funding, the notice to proceed, and selection from the pre-qualified list were previously discussed and applied to this engagement. It is recommended that Hardwick serve as counsel for this transaction based on its status as an MWBE firm and its combination of experience and expertise. Hardwick recently served as co-bond counsel on the recent issuances of Transportation Development Corporation bonds to refinance bonds used to fund the construction of 2 terminals at JFK International Airport. Accordingly, staff recommends the retention of Hardwick for the bonds based on counsel's specific and necessary expertise as bond counsel, counsel's performance with distinction on the TDC bond issuances, counsel's rate proposal, and the ESD pre-qualification process. Finally, third item is a request to appoint the law offices of Joseph C. Reed, PA, counsel, or Joe Reed, as bond disclosure counsel to provide legal services to Baldac in connection with the issuance of the refunding bonds at Barclays Center. As noted, the other terms that apply to the other 2 firms also apply to this contract. It is recommended that Joe Reed serve as disclosure counsel for this transaction. This is based on the fact that Joe Reed's firm is a certified minority and women-owned business, previously served as co-counsel with Nixon on a dormitory authority bond transaction and an ESD transaction. Joe Reed also served as co-disclosure counsel on the recent issuance of bonds by the Transportation Development Corporation to finance the construction of a new central terminal at LaGuardia Airport. Accordingly, staff recommends the retention of counsel for the bonds based on its specific and necessary expertise as bond and disclosure counsel, its performance with distinction on the LaGuardia transaction, counsel's rate proposal, and the ESD pre-qualification process. Accordingly, the director is now being asked to authorize the retention of all three of these counsel as counsel to Baldac for the Barclays Arena refunding transaction.
Any questions from the directors?
No questions.
If not, are there any comments from the public on these three items? If not, I will entertain a motion for approval on all three procurement of legal services items.
So moved.
Seconded.
Okay, all in favor? Aye.
Aye.
Any opposed? Thanks. Jonathan will now present the final item on today's agenda, which is for board authorization to perform certain acts in connection with the sale and delivery of the Brooklyn Arena Local Development Corporation Pilot Revenue Refunding Bonds, Series 2016A and 2016B, federally taxable, and to appoint underwriters. Jonathan?
Thank you. The board is being asked to approve the operative provisions, sale terms, official statement, bond purchase agreement, and related documents, appoint underwriters, and take related actions in connection with the sale of the Baldac Pilot Revenue Refunding Bonds, Series 2016A and 2016B, federally taxable, together referred to as the Series 2016 Pilot Bonds. Brooklyn Events Center, LLC, a Delaware limited liability company and an affiliate of the developer, also referred to as Arena Co., has requested the issuer to issue the Series 2016 bonds, the proceeds of which will be used to refund all or substantially all of the Series 2009 pilot bonds to pay the cost of issuance of the Series 2016 bonds. Security. The Series 2016 pilot bonds are special limited obligations of the issuer. The principal and premium, if any, and interest as applicable are payable solely out of and secured by revenues of the issuer derived from the pilots to be made under the pilot agreement. All right, title, and interest of the Bank of New York, the pilot bond trustee, in certain funds and accounts held by that bank, the pilot trustee, under the pilot agreement and escrow agreement, among ESD, the issuer, the pilot bond trustee, the pilot trustee, and the City of New York. And, finally, all right, title, and interest of the pilot bond trustee in certain funds and accounts held by the pilot bond trustee under the Master Pilot Indenture of Trust, dated December 1, 2009, by and between the issuer and the pilot bond trustee, including by the fourth supplemental pilot indenture, dated on or around September 1st, 2016. The Series 2016 pilot bonds are being issued on a parity with the issuer's Series 2009 pilot bonds, which are not refunded, and will be on a parity with any additional pilot bonds issued in the future. The Series 2016 pilot bonds and the Series 2009 pilot bonds, which are not refunded, will be payable from the pilot revenues made by Arena Co. pursuant to the pilot agreement on a parity basis. As part of the transaction, the corporation will also enter into a bond purchase agreement for the initial underwriting of the Series 2016 pilot bonds. The corporation is also being asked to delegate authority to its officers to approve the maturities, prices, yields, and other terms of the Series 2016 pilot bonds. Underwriters. On April 19, 2016, ESD placed an advertisement in the New York Contract Reporter and otherwise publicized its request for proposals from firms interested in qualifying to serve as underwriters on a rotating basis. On June 1, 2016, 45 firms, including 13 MWBE firms and 3 service-disabled veteran-owned businesses, responded. Please note that certain non-substantive details regarding the description of the ESD process in the materials will be corrected in the final record to be filed with the corporate secretary. A team of staff from ESD reviewed and rated the firm's responses who were requesting to serve as underwriters. Rating criteria included experience, underwriters' ability to structure and sell bond issues, knowledge and technical expertise, capitalization, support of ESD bonds in the secondary market, and diversity practices. On the basis of the overall rankings of the proposals from the responding firms, the recommended group is comprised of 13 senior managers. Based on this ESD RFP review and selection process, staff now proposes for your consideration and approval engaging Goldman Sachs & Company as book-running senior manager and Siebert Brantford Shank & Company, LLC, a certified MWBE firm, and Barclays Capital, Inc., to serve as senior managers on the transaction. All three firms responded to the RFP, satisfied all of the criteria and requirements set forth in the RFP, and were ranked as senior managers by the reviewing committee. In accordance with the attached resolution, you are now hereby requested to approve the terms and authorize the sale of the 2016 bonds on a negotiated basis, confirm the appointment of certain professionals, approve the form and content of the official statement and various other documents connected with the sale and delivery of the Series 2016 bonds, and authorize certain officers and employees of the corporation to take all actions deemed necessary, including approving the specific terms, to accomplish the final sale and delivery of the Series 2016 pilot bonds. Thank you.
Any questions or comments from the directors?
No questions.
I do have a question. It's more out of curiosity because I was involved in this transaction in 2009. And I note that the pilot agreement is referred to in the materials, but it's not actually part of it.
Correct.
So, as I understand it, the bonds are serviced by the pilots, and the pilots are the exact equivalent of what would have been the real estate taxes had real estate taxes been able to be charged. Is that correct?
Well, exact equivalent, they can't exceed what...
Are they less than? Is it a
Yes,
negotiated pilot?
Yes, there's an estimate of what the pilots will be, and it can never exceed what actual tax payments would be.
Do you know what the pilots are in relation to what the assessments?
There is a chart actually in the offering statement.
I thought it were just numbers, though.
Yeah, it is, but it is in the offering statement.
Okay, I saw that.
Yeah.
I didn't know percentage terms. For instance, the Hudson Yard development, it's 19% of what the real estate taxes would have been for certain buildings. So I just, do you know?
I would defer to more of
It's 100%.
That's what I
It's
thought.
100%.
So here's my question, then, and this is more of derived from an anomalous situation I was once involved in. Can the arena tenants, I mean the Nets or whoever's ultimately is paying this, can they go challenge the assessment in a certiorari proceeding? And if they do, and they get the pilots lowered, first of all, can they do it? And if they can do it, is there anything else that backs the bonds, any other debt service sources?
Yes, they can do it, but in New York City there are 4 classes of property. This is Class 4 property, which is basically based on construction costs and an escalator, and so it's not an NOI-based Class 3 property, so the odds on doing that are very different from what you might be used to in a commercial office building. So the answer is, but the right to challenge exists.
But fair to conclude, no worries? No worries?
Well, it's fully disclosed.
Yeah. The underwriter's not concerned that the bonds will...
We're not concerned, particularly given the Class 4 classification here.
Okay, thanks.
Any comments from the public on this item? If not, I'll entertain a motion for approval.
So moved.
Is there a second?
Yes, there is.
All in favor? Aye.
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 Any opposed? First, I'd like to say, before I conclude, that there be no further business, to say hi to Peter. I haven't seen him in a while.
Bob.
Hi. And can I have a motion to adjourn this meeting?
I move that.
Second.
In that case, thanks, everyone, and that concludes our business.